Good morning. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission to consider issuance of proposed rulemakings under the Dodd-Frank Reform and Consumer Protection Act. I just want to make sure before I go on, is Commissioner Chilton on the line?
I'm here, Mr. Chairman, yes.
That's great. That's a yes. Terrific. Today we're going to be hearing from the team on two related rules. One is a joint rule with the Securities and Exchange Commission, which I understand that they voted out yesterday, and that's reporting on investment advisors to private funds and certain commodity pool operators. For the public, sometimes you think of these as hedge funds, but it's private funds and what we over here at the CFTC call commodity pool operators and commodity trading advisors on a new form, and that form is PF. Also, a related rule, one here just at the Commission and not joint with the SEC, is on commodity pool operators and commodity trading advisors, and this is to be consistent with the joint rule and some other important matters for us. Before we hear from staff, I'd like to thank Commissioners Mike Dunn, Jill Summers, Bart Chilton, and Scott Amalia for all their thoughtful work in implementing this act, and welcome members of the public and market participants, not only for their listening today, but also for their comments on these rules if we were to move forward. I just want to remind the public we do have additional meetings scheduled for February 11th and February 24th, I believe, as we normally do, starting at 9:30. We'll post 1 week before those meetings the subjects of those meetings. I believe today is our 11th meeting on the Dodd-Frank Act. With that, the staff led by Kevin Wallach will comment on this after we get other commissioners' thoughts on this. And let me just make sure. I think I'm going to turn to Commissioner Dunn.
Thank you, Mr. Chairman. I want to thank everyone for joining us today in what looks to be inclement weather here, and I'm certainly hopeful that our colleague, Commissioner Chilton, can get back from New York. This is an important meeting regarding the implementation of the Dodd-Frank Act, and today's meeting will address proposed rules regarding reporting by investment advisors to private funds, commodity pool operators, and commodity trading advisors, and amendments to the compliance obligations of commodity pool operators and commodity trading advisors. The proposed rule regarding reporting by investment advisors is a result of collaborative efforts on the part of the Commission and the Securities Exchange Commission. Today's proposed rule requires investment advisors to provide certain information to the SEC and the CFTC, enabling better monitoring of emerging risks to the financial stability of the United States on a system-wide perspective. Information collected would be shared with the Financial Stabilization Oversight Council for use in monitoring such risks. I look forward to the public comments on this proposed rule. The proposed rule regarding the compliance obligations of commodity pool operators and commodity trading advisors provides for new data collection for CPOs and CTAs consistent with that required under Dodd-Frank Act. I also look forward to the public's comments on the proposed rule, particularly in regards to whether there are additional risk metrics or market factors that the Commission should require CPOs to employ. As I have mentioned in previous open meetings, the CFTC today faces a severe budget crisis. At our current funding level, the Commission is under serious strain. The lack of staff and resources necessary to both implement Dodd-Frank and continuing to fulfill our pre-Dodd-Frank duties under the Commodity Exchange Act. Without additional fundings, the strain will only become worse in July when much of the Dodd-Frank goes into effect. The lack of staff and resources leaves the Commission with a very hard choice as to how to use our limited resources to enforce both Dodd-Frank and the Commodity Exchange Act. From the offset, this rulemaking process, I have expressed my concern that our budget crisis would move us from a principle-based regulatory regime to a restrictive regime. Without additional funding, we cannot acquire the human and technical resources for optimal regulatory oversight. I fear the results will be a restrictive regulatory regime that will have a negative impact on both the futures and swap industries in the United States. Mr. Chairman, I would like to once again thank the staff of the CFTC for all of their hard work in regard to these very important rules. Their dedication to their important work during this difficult time is what government service is all about, and I salute them.
Thank you, Commissioner Dunn. I appreciate the salute to the staff because they are really putting in long hours and are very thoughtful and excellent work. Usually I turn to Commissioner Summers, who is representing this commission ably at international meetings, I think in Brazil. So I'm going to turn to Commissioner Chilton.
Thanks, Mr. Chairman. And given the weather both in D.C. and here in New York, makes me think that these Part 4 rules have been so helpful in disclosure over the years that they protected people from, being victims of a blinding snow job. And today's rule is more about transparency. Both the rules are about transparency, and that's critical. When I talk with people and I say what the Dodd-Frank law is all about, the thing I put paramount among all of that is transparency. And so Kevin's done a great job. The SEC's done a great job on this, and I commend them all. The last little point I wanted to make is this discussion that all of us continue to have amongst ourselves and my colleagues and in public about the funding. And a lot of the things that we're hearing now are really symptoms of a larger problem. I think that the chairman's done a great job with this challenging budget situation that we're involved in. If you think that Congress would give us the authority to regulate a large portion of the $600 trillion OTC market, nobody would imagine that they wouldn't give us the resources to actually do that. So given where we are, we're, I think, doing exactly the right things. There are little idiosyncratic things that'll pop up here and there, but they are all symptoms of a larger concern, which is we can put these rules in place, we can have them on the books, but without the additional resources, we won't be able to enforce them or oversee the markets that like Congress instructed us. So I think we need to be creative and think out of the box about how we deal with this dilemma. And I'll be talking a little bit later about that today. But I think all of us know that there are things that need to be done. Otherwise, without the enforcement and the oversight, we could be really back where we were 2 years ago when we saw this economic calamity sort of take hold. So thank you, Mr. Chairman. Appreciate all the work of everybody. Thanks.
Thanks. Good to see you on the video, Commissioner Valiant.
Thank you very much. We have before us today two related proposal rulemakings that address reporting requirements for commodity pool operators and commodity trading advisors. I want to thank the team, Kevin, Amanda, Daniel, and Eileen, for their very hard work and thoughtful efforts on this proposal. It is my understanding that the substance of these two proposals reflects a great deal of coordination with both domestic and international regulators, consultation with the Financial Stability Oversight Council, and discussions with the NFA, so I'm grateful for the team's efforts to coordinate those efforts. I'm pleased to be able to support the proposed rulemaking that in part rescinds certain exemptions from the registration and reporting requirements for CPOs and CTAs. In September of last year, I wrote in support of similar changes proposed by the NFA to Commission Rules 4.5. At that time, I noted certain registered investment companies were offering a series of de facto commodity pool interests, yet claiming exclusion under the regulations of 4.5. This resulted in some registered investment companies offering futures-only investment products like futures mutual funds without becoming subject to CFTC oversight. I continue to support the repeal of certain exclusions to the registration requirements for CPOs and CTAs so that we can close the regulatory gap that allows some registered companies to offer futures-only products outside of the Commission's jurisdiction, especially its anti-fraud authorities. I noted that the team has taken the opportunity with this proposal to ask several questions of the industry. I counted no fewer than 45 specific requests for comment in this proposal, and I appreciate the team's efforts to listen to the industry as they craft this rulemaking. I'm also pleased to support the proposed joint rulemaking with the SEC. The rulemaking will adopt certain reporting requirements required of Title IV of the Dodd-Frank Act. I believe the team has done a great job to make common sense proposals, especially related to the treatment of entities registered by both commissions. I'm eager for the industry to provide feedback on the proposal, and I look forward to the discussion today. Thank you very much.
Thank you, Commissioner Malia. Before we get going, I want to do two administrative things. One is out of an abundance of caution. We noticed this meeting 7 days in advance, and I'm told that's in compliance with the Government Sunshine Act. But apparently the Federal Register didn't put it in the Federal Register. And I'm sort of told we did comply with the Sunshine Act, but just in an abundance of caution, I'm asking, I guess, just, let's see, that by and entertain a motion that we determine the commission business and importance of the issues we're addressing necessitate holding this meeting today, just in case somehow, because it wasn't in the Federal Register.
So move.
Second.
All in favor?
Mr. Chairman.
Any opposed?
Mr. Chair.
Yep.
That's fine with me on the motion. I did want to make a quick comment on this because this issue has come up, and I don't know if you want to expand on it too. I don't want to slow us down too much, but there's been an issue. We've been getting emails lately about a delay in our proposal on position limits, saying that the 60-day comment period is being delayed by the agency, and I know that's not the case, that we did some technical corrections as we do on all of these rules, but the Federal Register is actually a separate agency that doesn't have anything to do with the CFTC other than we are one of their clients. And when we put these rules, give these rules to the Federal Register, there's a backlog, and sometimes they don't get printed on time. So lots of people have been emailing lately, and just like this example where it wasn't noticed perhaps when we would like it, we don't make that call all the time, and I want to alert people that there's nothing nefarious going on, and the CFTC isn't delaying the comment period. We are merely in queue to get published.
That's absolutely correct. In fact, in this circumstance, we did notice this meeting. It's just that the Federal Register then published it a day or two later. On our rules, I think on average, and people could correct me, the Federal Register has been publishing them somewhere 7 to 10 days after our meetings. We would like them earlier, but if the Federal Register is doing a professional job, and I'm sure they're dealing with not only our publishing, but things that are being published throughout the government. And I think that on the position limit one, we put it on our website because of the interest, just as we do in everything, even though it might be in the Federal Register several days later. David Stawick is shaking his head yes, our secretary.
Our standard procedure, Mr. Chairman, is that when a rule is sent to the Federal Register, we forward that, my office forwards that to the Office of Public Affairs, and it's put on the website.
Great. One other administrative matter is that Commissioner Summers, who's representing us down in Brazil, as I said, is unable to join us today. She has requested that she be permitted to vote by limited proxy for all votes taken at this meeting, a procedure that we have utilized in previous meetings, and to that end I request unanimous consent to permit limited proxy voting for the votes subsequently taken in this meeting without objection. So ordered. So with that, Kevin, Amanda, Daniel, Ananda, anybody else who gets pulled to the mic? The floor
Thank
is
you,
yours.
Mr. Chairman. I'm going to hand it over to the excellent team that did the work on this proposal. Kevin.
Thank you, Mr. Chairman and Commissioners. I would be remiss if I didn't add a few people's names to the list. The team was a little bit larger than the four that Commissioner O'Malley mentioned. We also had on the team Adrienne Joves before she went to Commissioner O'Malley's staff on our team. We also had Carl Kennedy from the General Counsel's office. And last but not least, of the persons that weren't mentioned, I have two more. We had Barry McCarty from the Division of Enforcement, and we had Jake Presarovich from the Division of Clearing and Intermediary Oversight. So we had a very good team in this operation. I would also be remiss if I were not to thank our colleagues over at the SEC. In my 34 years of government experience, this has been the most collegial interagency effort that I have ever been involved with. And in fact, we even have one of the members of the SEC team in the audience today who helped and worked with Dan on preparing the data collection instruments sort of to give us moral support or cheer us on. So I think that's indicative of the type of work effort we had as a joint SEC-CFTC team. With respect to the specific presentation today, we are presenting to you for consideration 2 notices of proposed rulemaking. As you noted, all have noted, the first notice of proposed rulemaking is the joint rulemaking. And this is the joint SEC-CFTC rulemaking to collect data for dual registrants greater than $150 million. Someday probably they will be greater than $150 billion too, but in this case, $150 million. There is a tiered approach, and we'll talk about that more later, but there is a tiered approach between those entities that are smaller pools at the $150 million level and those that are greater than $1 billion. Then the second notice of proposed rulemaking, as was noted in several of the presentations earlier by the commissioners, is to deal with certain CFTC compliance issues to make a more level playing field, to put light onto what were previously dark markets, and to, in fact, ask parallel questions and provide parallel information between similarly situated types of investment vehicles. Specifically, the second notice of proposed rulemaking, because that's probably of most concern to those here in CFTC, we have a provision to reinstate trading criteria for registered investment companies claiming exclusion from CPO definition under Regulation 4.5. This was what Commissioner O'Malley mentioned was the NFA's proposal earlier that we are carrying forward. We have a proposal, in the proposal we have a rescission of the exemption from CPO registration under Regulations 413A3 and A4. These two sections are commonly referred to as the de minimis and the sophisticated investor equivalents on our side. The third item that we have contained in here is a revision to Regulation 4.7 so that CPOs may no longer claim the exemption from the requirement that an exempt pool's annual report contain certified financial signatures. Interestingly enough, in this context, the 4.7 entities, it's been our information from looking at the actual filings, that over 80% of the 4.7s were getting certified annual reports anyway. And that was due to their investors wanting the certified annual report. So we're really only providing that portion to a very small group of even the 4.7 entities. We also have included in that second notice a provision to modify the participant qualification criteria of Regulation 4.7 to incorporate the SEC's accredited investment standard by reference rather than by direct inclusion of its terms. What was happening is that if the SEC were to change the terms, we would have to change our regulation and have to re-regulate. But by doing a cross-reference, if they change theirs, the cross-reference applies and carries through that change that the SEC may have made. So it doesn't require us to constantly modify our regulation. We also have included a requirement that all persons claiming exemptive or exclusionary relief under Regulations 4.5, those remaining sections of 413, and 414 to confirm their notice of claim of exemption or exclusion on an annual basis. One of the issues that may come up as you ask questions, if you ask questions about specific numbers, I may have to give you an answer that my best guess is, because of the way our notice process has worked in the past. Our notice process has indicated when someone is eligible for the exemption, but it never tells us when they leave. And so as a consequence, we're not sure of all the entities that have left or what the total size of that population is. And last but not least, in the second notice, we have a provision to amend the risk disclosure statement that must be included in the CPO and CTA disclosure documents to describe certain risks related to swaps transactions. This is to bring that risk disclosure statement for CPOs and CTAs in line with the rest of the Title VII actions that have been happening as we've been proceeding through this series of Dodd-Frank rulemakings. And with that, I'm happy to, and I and the team would be happy to entertain any questions you may have.
Thank you, Kevin and team. I support both of the rules, and I'll have a statement for the record. But I think that what this importantly does is brings more transparency to the regulators, to the Securities and Exchange Commission primarily on their responsibilities, but also the CFTC and the members of the Financial Stability Oversight Council. I think that the intent of Congress, as I understand it, was to get this information for systemic risk monitoring, systemic risk reporting. I believe the SEC even calls it systemic risk reporting. They might have in there. Somebody from the SEC was here, but I don't want to put them on the spot. So I think that's very good, and there'll be important information. I think it's also good that we bring ours in line, because I understand the joint rule, and so this is a question, Kevin. The joint rule is for those investment funds or private funds that are either solely regulated by the SEC and, in addition, jointly regulated with us. Is that correct?
That and greater than $150 million.
Thank you for that correct. So anybody over $150 million that's either solely regulated by them or jointly with us.
That is correct.
But our companion one is on what we call pool operators or commodity pool operators and advisors who might only be regulated by us that are over the 150.
That is correct.
So that's why we have these companions.
That is correct.
So I think that's very good that it's consistent. My question is somewhat on the numbers. And I don't expect you to have the exact number at your fingertips, or maybe you do. But how many private funds would fall into the category of that would have to comply with this? And I know there's two levels. It's over $1 billion and over $150 million, if you have that type of information.
Our rough estimates in that area were somewhere slightly around 200 entities were likely to be filing, of our entities, were likely to be filing the PF, Form PF, the joint form. That does not, however, include what our guesstimate might be of those 413A3s, which is the de minimis exemption, that might come back into both the registration with the SEC and us, and as a consequence be captured. And that number, again, going back to the fact that we don't have the filing of who still is or isn't exempt under 413A3, it could be anywhere, I mean, I've made rough guesses anywhere from 1,000 to 5,000.
But the 200, is that the over $1 billion, or is that over the 150
That's the
million?
over $1 billion.
I'm sorry, Amanda?
It is, I'm sorry, it is above 150.
Okay,
Amanda's
I see.
correct.
All right. Terrific. Commissioner Dunn.
Thank you, Mr. Chairman, and I want to commend our staff on working very closely with the SEC and with IOSCO. And I know that Commissioner Kathleen Casey at the SEC has worked very hard on harmonizing this type of information through the IOSCO survey and getting that information, and it, to me, gives me a great deal of hope that we can have harmonization of our regulations internationally. I'd like to pursue a little bit, Kevin, on what you just talked about, and the proposed rule requests comments on whether any entities that have previously claimed exclusion under Section 14.3A3 and A4 should be exempt from compliance with the proposed revision. Should the commission consider other de minimis exemptions, and if so, what should that criteria be for such de minimis exemptions?
That is something that the team has not talked at length about. It has come up in a couple of conversations with other commissioners as well. I think that it may be appropriate to consider another de minimis level, but clearly the way things are structured right now we felt it was better to rescind 413A3 and then through the collection of answers to the question, get a better sense of what would be. And in fact, I think at one point this morning, I was talking with someone about the possibility of making another additional change to that question in the document to ask specifically, would there be that? And to basically take your language and insert it in what we already have asked and make it part of the release. And so, depending upon, I think you'd have to have unanimous consent to do so. But we would be happy to entertain such an amendment to the document.
I'll let my colleagues think about that a little bit. I don't force anything on them.
Here, but thank you for Robert's Rules of Order. That's the same one, right? Yeah. So, I mean, I'd like to ask unanimous consent that we just, I think that we already have a question on this de minimis, but that we add some language that staff works with the legal assistants on that basically asks the public, if we were still to have some de minimis, what criteria would be most appropriate? I think that's the spirit of Commissioner Dunn's question.
Consider it done.
Thank you. Now, as is my want to do, I turn to the division director and ask, do we have the staff to consider these requests?
The staff that will be looking at the information flow are these excellent people right here. So if you're asking me, do we need more, the answer is yes.
Well, if there are going to be, I don't know, out of 200, 150 or so requests, I'd like to know what's it going to cost us and what is it we're not going to be doing when we're doing this.
Well, I'm not sure how many people. I think I may have asked for an additional 10 people. I need to check on that to do this and other information that the managed fund. This is the managed funds unit, and I think that what I'd asked for was an augmenting so that the managed funds unit gets to 10 people, so that we could discharge the responsibilities that the commission may decide that we need to do. Basically, if they're going to be concentrating on the new responsibilities, then unfortunately something will have to give, and it may be current responsibilities that we may not be able to discharge with alacrity. We take pride on discharging all of our responsibilities. Sometimes the issue is, which do we get to first?
I will forewarn you, when it comes time to a final rule, I'll want some
Sure.
concrete information. Mr. Chairman, were you going to interject something? Or we are asking for additional information, and it's pertinent to know what are we doing with that information. And a good part of this is going to the FSOC. And I would ask you, what's the intention of the FSOC with this additional information?
As a member of the FSOC, I don't think I could speak on behalf of all of the members, but as I understand it, the information that comes to us is to assist in monitoring for systemic risk issues and making recommendations on that, and that the investment advisor and private fund area is one that Congress gave the SEC and CFTC this joint authority really to address that systemic risk reporting. And so I think that's why in this case, even though Congress said over $150 million size to have reporting, we've kind of tiered it, and the greater than $1 billion where there's a lot, where they, because it's about systemic risk largely.
Just for public knowledge, where do we see the breakdown of these hedge fund advisors coming from? How much are in the U.S., how much under the FSA? and then other entities that are regulate, like Hong Kong?
At our last meeting that we had in Rome with the TFU, the Task Force on Unregulated Entities, the estimate that the group was working with by throwing numbers around is probably 95% of these private funds that some people like to call hedge funds lie within the jurisdiction of the United States.
Thank you.
Thank you, Commissioner Dunn. Commissioner Chilton.
Thanks, Mr. Chairman. Kevin, I think the chairman was asking this question about the numbers of folks, but I know that we're talking about NFA being the custodian here, some of these records, but that still is going to have an impact on our budget too, correct? Any comments on that?
As Ananda was alluding to, I don't know what the out years were, but I know that we had already had budgeted for this year 3 additional staff, which we are unable to get, at least at this time because of the budget situation. Those persons we were hoping would be the persons working in concert with the NFA in, once this rule became final, to actually make sure that the data was being collected in the manner most conducive to our needs, as well as integrated with the information being collected by the Securities and Exchange Commission so that they could be packaged in a logical fashion. The good news is in that picture is that, yes, the NFA is part of it, and we have worked with the NFA staff over the years with their data collection already of most of the information for CPOs and CTAs, and they have done an excellent job in that area. And this is an expansion, in fact, of a data collection, which was already called PQR, that NFA instituted and collected for the first time this last March. So we're basically expanding upon that collection. And so I think that at the very least, the data can be used for purposes of honing and improving their selection of candidates for examination, but also by their experience, they can work with us in coming up with quick and easier ways to package the information. Is it a perfect answer? No. I think Ananda's answer of the needing of the staff is the perfect answer. But after 34 years in government, after 34 years of government going up, watching the budgets go up and down, this is my 3rd instance where I've seen something like this happen in my career. And amazingly, the staff gets us through it.
Yeah. Good folks. The other thing I had was really just a comment, and it follows up on what Commissioner Dunn was saying about the exemptions, or asking about the exemptions. I think the comments are going to be real important here. As we know, we saw a FOIA exemption repealed by Congress, the SEC's FOIA exemption repealed by Congress. So we just need to make sure we get it right. And so I think you've done a great job here, but we'll look forward to the comments. Thank you, Mr. Chairman.
Thank you, Commissioner Chilton. And before I go to Commissioner Malia, I'm sorry, because on the numbers, my earlier question, if you can turn to page 77 of, I think I might have, the pagination of the one I printed out might be different, but of the joint rule. But what it is, it's in the middle of the Paperwork Reduction Act stuff. And again, because the pagination sometimes when you print, what's that? It's the joint rule with the SEC. So it has burden hours and how many hours it takes, to fill out the forms, and 10 hours to fill out this and 3 hours to fill out that. And then at the end, again, if I have a different page pagination, but it says, assuming that there are 2,180 smaller private fund advisors, 200 large hedge fund advisors, 80 large liquidity fund advisors, and 300 large private equity fund advisors, and then it goes on. So my question again, just with this in front of me, how many, is this large private fund advisor meaning large over $1 billion or large over 150? I'm sorry, Amanda?
Over $1 billion.
Over $1 billion. Mm-hmm. So then it is, because there was a little back and forth, it's the 2 to maybe 300 that are over $1 billion, and it's a greater number that's over the 150 maybe.
Well, I think the numbers that Kevin mentioned earlier, the 200 that he was referring to were the joint registrants, and those were over 150 million. The 200 large hedge funds that are mentioned in the paragraph or in the sentence that you just read would include also SEC only. Funds.
I see. There's the joint and the
Right.
SEC only, and
Right.
there's a coincidence in the numbers.
And that's-
Exactly.
And that's where I make,
Thank you.
because the numbers are so coincidental, because the numbers are coincidental, that was the reason for my making the error, and thank goodness Amanda had that already parsed out.
But in essence, when you combine the SEC and us together, this page, the numbers I just read is a good estimate together. This 200 to 300 that are over $1 billion.
Right, yeah. I mean, those are good numbers that you just read that would cover the joint registrants and the SEC only registrants.
That's right. I mean,
Correct.
again, it's an estimate and
Right.
so forth. All right, thanks. Sorry, Commissioner Mahia.
No trouble. Will these forms be filed electronically?
Yes.
Perfect.
In fact, one of the dilemmas that, as a matter of fact, with Mr. Bartel here from the SEC and Dan, they can both tell you that when they tried to take the electronic form and turn that into hard copy, that's when it grew to so many pages. Because when it's an electronic form online, a lot of that is pull-down menus. But you
Right.
can't show a pull-down menu on a hard copy.
And that's off the NFA though, right? That's all NFA
The PQR will be collected through the NFA's electronic system that already exists. But there will be, for certain large entities, there will be additional information from what they're currently doing. But the form that they go to, they're already familiar with how to get onto the system, how to fill out that first portion of it. One full schedule out of the 3 schedules is already in existence.
Oh, bless the NFA. Let me ask you a couple of questions on Rule 4.5. What type of risks do you believe are present when we don't fill the regulatory vacuum that's left without the modification in this proposal?
I think that there is some argument, and Dan's worked very closely on the 4.5 issue with the NFA as well, and he may want to add to this. But I think that the largest, in my mind, the largest vacuum that is filled is that the SEC themselves, up through the chairman's level, has indicated to us that we have a better knowledge of the commodities trading done by the 4.5 entities, the mechanisms involved, the nature of the leverage involved, and as a consequence, we have more of the knowledge to regulate them correctly. And I think that's with it just being an SEC registrant only, that would be the vacuum.
Well, my next question was, what is the SEC's opinion of this? But you've solved that for me, so I'm
Yeah.
fine. Thank you very much for the hard work on
I
this.
probably have divulged something I shouldn't have.
I was going to ask you the question anyway.
I also want to ask unanimous consent to adopt a question proposed by Commissioner Summers regarding 4.5, I think. But I don't know if this has been, pre-walked around, so I'm just going to read the question. But currently in our rule, not the joint rule, but in our rule, we have this issue of 4.5, and there's a question that already exists that says, additionally, the commission soliciting comment regarding implementation of the changes of 4.5. And then it would have an additional question that just said, what issues should the commission consider with respect to the ability of registered investment companies to comply with the disclosure document and reporting delivery requirements, record-keeping, related fund performance disclosure requirements under Part 4. Asking unanimous consent and not hearing objections, we'll add this question from Commissioner Summers from Brazil, or here. I think without further questions then, did I properly entertain a motion before we asked our questions? So I've, messed that up. So I entertain a motion. I'll entertain a motion to accept the staff recommendations, issue proposed rules. I'll do it on the joint. I'll do the joint one first, on the joint rule.
So move.
Second?
All in. So that's the motion. These unanimous consents, do I have to do them again because now it has to be on a live? No. All right. Good. Thank you. Mr. Staywick, call the roll.
Commissioner O'Malley?
Aye.
Commissioner O'Malley, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Commissioner Summers, I have a proxy, is aye.
Commissioner Summers, aye by proxy. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
Thank you. We'll be sending that to the Federal Register. Do I hear a motion on the second staff presentation, which was on the Arab rule?
Motion to approve.
Second?
Do I need to do anything about the unanimous consents that I did early? Was that, no? All right. Here we go. Yeah.
Commissioner O'Malley?
Aye.
Commissioner O'Malley, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Commissioner Summers, aye by proxy.
Commissioner Summers, aye by proxy. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
Thank you. With that, too, we'll send it to the Federal Register. I might need to do what I normally do, which is something about technical amendments. Yes, so I'd ask unanimous consent that, whatever technical amendments, particularly to get these questions that were raised by Commissioner Dunn and Commissioner Summers in, be accepted. Without objection, that be so moved. Is there any other business? Before we seek to adjourn, I think Commissioner O'Malley wanted to say something about the Tech Advisory Committee.
Thank you, Mr. Chairman. Obviously, due to the weather forecast here in Washington, it's probably a bad idea if we bring everybody here and let them be stuck here for the rest of the week. So we're going to postpone the TAC Advisory Committee for tomorrow from 1 to 5 o'clock for a date in early February. We're still working on coordinating everyone's schedules, but we've let the participants know and the members know so they can accommodate their flight and train changes and hopefully not get stuck here if the weather is as bad as they're predicting. So we'll reload this for as soon as possible. This is a great talking about the issues related to implementing Dodd-Frank. What do we need to think about? How are we going to physically hook this up? Under what time frames and at what cost? A lot of interesting discussions I learned of in New York earlier this week, and we have some really great people presenting on that to talk about. Just give us things to think about in implementing this thing. And we are also going to have a report by Dr. Gorham on the subcommittee on pre-trade functionality and kind of doing a survey of the best of the best to figure out what we're going to do going forward. So we obviously want to reload that as soon as possible and to tackle those issues in early February. Thank you.
No, I think that I can speak for all the commissioners. We look forward to hearing from Dr. Gorham's report, and I know that we have, we'll probably have to put his report in our comment file because we have live proposed rules for designated contract markets and for swap execution facilities that those comments might be very informative for, and maybe for other areas as well. So, with that, I'll entertain a motion to adjourn the meeting.
So move.
Second.
All in favor?
Aye.
Any opposed? The meeting will be adjourned. I think our next public meeting will be February 11th.